Hello and welcome to Jaw Law. I'm your host, Joe McGregor from Dallas, Texas, from the law firm of McGregor and Doblad. And today we are talking about the Corporate Transparency Act.
Any material communicated on this podcast is for general informational purposes only and is not intended to be legal advice. Nothing herein should be considered to create an attorney-client relationship. Please consult an attorney for legal advice on your matter.
Okay, so this is somewhat of an emergency podcast because a little while back ago, a little quietly, the Congress enacted something called the Corporate Transparency Act. It was designed to be able to track down those who launder money through shell corporations. The idea is that even though you register an entity with your state, the federal government wanted to have a registry that lists out all those who own entities and even those who form the entities on your behalf. They wanted to have a registry for the federal government's use so that basically law enforcement's accoutrements, they would be able to use this registry to find those who were avoiding taxes, using companies so that they could hide who owns what. Now, this was not going to be available for the public, just for use by certain federal agencies. And furthermore, this had some reporting requirements where anybody who had filed an entity had to register with FinCEN, is what they called it. They had to file a BOIR, Beneficial Ownership Interest Report. And then ongoing, anybody who will file an entity has 90 days to file this BOIR. As you can imagine, a lot of people want to keep their ownership of a certain entity quiet. They don't want people to know about it. And there's 101 reasons. A few of them are because they're criminals, and a lot of them are just people who like privacy, people who don't want to make it easy on litigants. Perfectly reasonable reasons that you want to keep ownership as quiet as possible. Well, FinCEN threatens that. Corporate Transparency Act kind of threatens that. And as you would expect, as soon as it got enacted, people sued. And just yesterday or 2 days ago, a court in eastern Texas, shocker here in Texas, a judge found that the Corporate Transparency Act is likely to be unconstitutional and therefore has suspended the reporting requirements for now. Now, what we've got to talk about is what does this mean to you, especially you who have already have an entity and have filed a BOIR, and those who have an entity and have not yet filed a BOIR. And one of the reasons this is so important to people is that there are pretty stiff financial consequences to not filing this BOIR. So it's important to you. Number one, if you have already filed, no harm, no foul. It's not going to hurt you if you have filed. This data is not supposed to ever be made public. So even if this is struck down, nothing's wrong. If you have not filed, the best news here is that you probably get an extension in order to file. So theoretically, if you filed an entity like in 2014, but you didn't actually know about this BOIR report, and you're supposed to have it filed 2024. And honestly, most people probably don't even know about this. So there's going to be like hundreds of thousands of businesses who are going to miss this filing. Well, the good news is that with this injunction, the deadline's probably going to get pushed back. So you'll have time to make this filing without getting penalized. But next we need to talk about what does an injunction mean. An injunction isn't a winning of the case. So when two parties, specifically here, when someone brings a lawsuit against the federal government saying, hey, this is illegal, then what they're doing is they're waiting for a court to strike it down or uphold this law. Now, occasionally there is an argument, well, hey, court, if you wait too long, and we all know court cases take forever to wind their way to a conclusion. And so once in a while, someone will say, court, we can't wait this long. You need to do something right now. And that's called injunction. It gets called a lot of things, but like a restraining order. Most people have heard of a restraining order. This is the same breed of animal. And in order to get a restraining order or an injunction, then you need to prove two things. Number one, you've got to prove that you would probably win in court. So your case can't be just a dog case and still get an injunction. You have to make your argument. And number two, you have to show that if we waited until the end, like the end of the case, that would be too late. The damage would already be done. And this judge in East Texas determined that the plaintiffs did that. So for right now, they won the injunction. What does that mean? What it means is temporarily we are suspending this requirement until it gets concluded. Now, what do I think about this lawsuit and this decision? Because, it's going to affect you. My opinion, and this is just my opinion, and the lawyers are wrong all the time on this. There's always, every time you have a court case, you have lawyers who think they're right and win, and lawyers who think they're right and they lose. Happens all the time. My opinion is that, I read the actual opinion of the judge. I think it's really over the top, and I think his arguments are actually pretty weak. So over the top that I can't help but think that this judge has political aspirations. And that's all I'll say. It's more about the way it was written than the actual substance of it. It just has a certain feel. And if any attorneys are listening to this, I think you'll know what I'm talking about. It feels different than a normal case. And I compare this to the case against the FTC where we saw litigants argue against this non-compete ban. That case was pretty benign and pretty bland. Like the judge is just walking through the law and just applying the law. This case, this decision, like I said, a little over the top from what you would expect to see from a legal opinion, and makes me think that, okay, this judge is making a statement, possibly raising his hand, saying, hey, next president, choose me for a higher seat in the court system. Or otherwise. Anyway, I only say that because I feel like the judge probably wanted this opportunity and is using this opportunity. I don't know that I considered the legal reasoning to be very persuasive. And in fact, each reason that the judge gave, so like anonymity, well, the reality is almost every state, except two, there is a lack of anonymity. They're public filings. That's kind of come and gone. That's past. And, is it necessary and proper under the Commerce Clause? Well, we already have reporting requirements like this in commerce because they're trying to say, hey, only the states can authorize these entities. You can't have the federal government oversee these states, but that already happens. That's one argument is the IRS. They already take into consideration, like for instance, an LLC is a state entity. It's not a federal entity. It's organized under state law. And in the IRS code, there's not actually an LLC. There are some provisions that tell us how to treat an LLC. But as far as the LLC goes for the IRS, it is when you file like an EIN, it's not a limited liability company. You're basically filing, hey, how am I treating this in terms of taxation? And so we already have some analogies in our regulatory atmosphere that seem to cut against this judge's argument. So it's entirely possible that this winds its way up the courts and the Supreme Court will say, yeah, Corporate Transparency Act, this is bogus, throw it away. And everybody who filed a BOIR, useless. I don't see that. Where I thought the FTC argument was pretty persuasive, and I don't think that is probably constitutional. Here, I'm a little less certain. I don't know that I found the judge's reasoning persuasive. A better judge, higher up the chain, may come out with some arguments that I think are better, more persuasive. But if we're just going on this judge's arguments, I'm inclined to think that this injunction it expires and the plaintiffs probably don't win the case, and we end up having to do BOIR reporting requirements. So maybe a lot of that is stuff that I don't know that you're terribly interested in, except for if you filed already, don't sweat, just hang out. It's probably going to show back up. If you have not yet filed and you do file, no harm, no foul, but you are not at the moment obligated to do so. And for those holding out hope, there is a chance that you are right, that you don't have to file. I don't think that's where this is going to go. I predict that we will have something that will require us to file these BOIRs. I could be wrong. It just could be completely wrong. And it may be the case that there's some modification to the law, that the judge or a judge or court strikes down part of it. And we end up having some form of the BOIR, just maybe not in its current form. But so for right now, if you haven't done it, fortunately, you're not under this 2-week or 3-week time requirement to get it done this year. But there you go. That's the update. And when we see further update on this, we'll come out with another pod, and hopefully it won't be an emergency pod. We'll have a little more advanced notice. But here we are today. Hope everyone has a great day. Thank you so much for tuning in. We'll see you next time.